Ladies and gentlemen, good morning, good afternoon, and good evening to all of you joining us today. Thank you for taking the time to be with us, and a very warm welcome to the M&A Academy program to what is our sixth webinar in 2024. My name is Surbhi Kejriwal, and I'm an M&A partner in Khaitan's corporate group based out of Bombay. On behalf of the firm, I would like to extend a very warm welcome to all of you to this webinar. The M&A Academy program is designed to provide foundational legal knowledge and understanding on M&A transactions and the various processes to all stakeholders in an M&A deal, including corporate executives, in-house legal teams, and various other stakeholders. The topic we've chosen for today is employment and human capital issues in M&A transactions. You will see the agenda on the slide that is visible to you. We've already received several audience questions for this webinar. Audience interest is already peaked, but do keep your questions coming. There's a facility provided in the webinar portal. Please use that to give us your questions. I can't promise that I'll be able to cover all the questions given our time constraints. I will, however, try and cover most of the topics, and be rest assured that we will separately respond to each of your questions post this webinar. We will also share a copy of the presentation, summary notes, and a recording of this webinar via a link to all of you who've registered. I would now like to introduce this topic. As you know, M&A is a very important part of our firm's practice. We have significant resources devoted to mergers and acquisitions. We have more than 50 partners concentrating on M&A. As part of our M&A Academy program, we will today be dealing with employment issues in an M&A transaction. Now, the criticality of this aspect in deal making cannot be overstated. As you may be knowing, India has a complex web of laws relating to hiring, maintaining, and exiting human capital. It is absolutely essential for all deal makers to understand the gravity of this issue to avoid any post-deal complications. While scaling businesses inorganically, there is a near certain potential disruption for employees in terms of restructuring, positions, perks, integration, so on and so forth. Indian labor law is complex. The landscape is constantly evolving. New laws are constantly coming in. Judicial precedents are constantly coming in. And now, the given added emphasis on ESG, it has become absolutely critical for M&A deal makers to understand employment issues in an M&A transaction. And so we thought this is an essential topic for us to deal with as part of our M&A Academy program. Now, as an M&A lawyer, I have been doing this for about 17, 18 years. And for a majority of those years, I have a trusted go-to advisor in our firm who I go to for almost all my M&A deals. Mr. Anshul Prakash. Anshul heads our ELB practice in Khaitan. And Anshul and I have been dealing with this for almost 15 plus years. Those of you who've registered for this webinar should have received Anshul's introduction and summary of his credentials. Not that he needs any introduction. So without wasting any further time, I'll now hand over the baton to Anshul. And Anshul, why don't you take us through some of the most important issues that one has to deal with in M&A deals? So over to you, Anshul.
Thanks so much for the kind introduction, Surbhi. Greetings of the day for all attendees here. It's a pleasure to have you here, and thank you so much for this opportunity. Now, over the next 1 hour, my objective shall be to provide you with an overview of certain key employment law related implications that parties may come across during a corporate transaction, and the manner or processes to navigate such issues. While corporate restructuring provides an edge to organizations from a market standpoint, it is equally important for the parties involved in the restructuring process to ensure that interests of the employees are not negatively or adversely impacted during that process. So it's not just about adhering to the legal provisions, it's also about ensuring that you follow the best practices when dealing with issues emanating from the HR domain while you are navigating through complex corporate transactions. Now, in this presentation, my intent is not to delve or deep dive into all the issues and procedural requirements that parties need to consider while entering into any arrangement that results in corporate restructuring of entities, but to discuss the critical legal requirements that the parties need to be mindful of and are required to comply with. So as you see on the slide in front of you, the most important factor which will go into the aspect of any corporate transaction as far as employees are concerned is classification of workforce. Now, Industrial Disputes Act, which is India's most significant industrial relations legislation, which governs employer-employee relationship, primarily provides for mechanism for settlement of industrial disputes, provisions with respect to unfair labor practices, layoffs, retrenchment, strikes, lockouts, and closure of establishment. The Industrial Disputes Act applies to and protects only a particular category of employees who are termed as workmen. Now, this is something which is important. We may be using employees and workmen as interchangeable terms, but the workmen category of employees may enjoy certain specific privileges and protections under industrial relations laws in India. Now, when I say workmen, the purposes of Indian industrial relations law would categorize workmen and managerial employees, or I would say non-workmen category employees. And the meaning of these terms, if you look at the screen in front of you, a workman is defined under the Industrial Relations Law of India as a person employed in an industry to do any manual, unskilled, skilled, technical, operational, clerical, or supervisory work for hire or reward. Of course, when it comes to exclusions, you need to pay attention to this one because there's a lot of misnomer around identifying workman category employees. Let me tell you, the salary of these employees, the monthly remuneration earned by employees is not the determining factor to categorize an employee into workman or non-workman. So the whole perspective of an employee earning a salary of 10,000 rupees per month is not the determining factor. It is only relevant for employees who are engaged in supervisory capacity. If they are earning more than this amount, they are categorized as non-workmen. Otherwise, irrespective of the designation a person may carry in an organization, the most important point here will be the test for an employee to fall under the definition of workman, and that is essentially the organizational setup and the role of such person within the administrative setup of the organization. The remuneration or designation of a person cannot solely determine whether he or she is a workman. To determine whether an employee is a workman, the actual or primary work performed by the employee needs to be examined. Now, substantive nature of duties and responsibilities forms the fundamental perspective basis which you can determine categorization of workforce. And this forms the very basis of the session itself, because all the way when we talk about the special protection in relation to transition of workforce, the whole perspective and categorization of employees will come into play. Some of these essential tests could be looking after the progress of work within the establishment, that is the quality and timeliness, ensuring compliance, manpower planning, contract management, monitoring costs, and mentoring team members. Of course, if an individual within the administrative setup is involved in policy making decisions regarding any aspect of the business or service, the conditions of workers, employees, and such other similar powers, it can be inferred that the concerned individual who is engaged in these aspects of the administrative setup of an organization would fall outside the category of a workman. Moving on to the next slide. Now, having understood the differences between the two categories of employees, let us now understand the implications of distinction, or what are the benefits that workmen enjoy in case of corporate restructuring, which involves business transfers, asset purchase agreements, or even mergers that are code driven. Now, at the outset and prior to delving into the benefits that an employee engaged in the category of workmen would enjoy in a corporate restructuring setup, do note that Indian labor laws do not envisage an automatic transfer of employment for employees who are engaged in an entity which is proposing to divest its business undertaking to another potential buyer or acquirer. Now, you need to be mindful of the fact that against the backdrop of any business transfer or asset purchase deal, there is no automatic transfer of employees who are associated with a particular business vertical, because the contracts of employment under Indian law are deemed to be contracts of personal service. Now, transfer of employees services on a service continuity basis is one of the most important elements as far as corporate restructuring is concerned, primarily when it comes to certain conditions that require compliance by both seller as well as buyer. And I already spoke about the Industrial Disputes Act, which forms the basis of any industrial relations issues emanating from a potential corporate restructuring deal. Now, the IDA, as we call it, provides for fulfillment of certain conditions for transfer of workmen, that is non-managerial personnel, in the event of transfer of an undertaking from one entity to another, such that the parties would be required to comply with the following conditions. As you see on the slide, the transfer of employees should be and must be on the basis of uninterrupted mode. They have to be provided continuity of service. They have to be offered terms and conditions of service that are no less favorable than the existing employment terms. And the most important point is consent of these employees who are proposed to be transferred along with the business undertaking that is proposed to be transferred as part of the corporate restructuring deal. Now, while the requirement of consent of the employees for transfer of their services has not been set out under the Industrial Disputes Act, several court judgments have emphasized on the requirement of seeking express consent of the employees whose services are proposed to be transferred from one employer to another employer who is acquiring the business vertical. Without the consent of employees, the transfer of services of these personnel cannot be effectuated. And if that is done, if that is effectuated, it is susceptible to challenge by the concerned employees who are otherwise proposed to be transferred along with the business. Now, in the event the employee whose services are proposed to be transferred from the current employer to the acquirer doesn't provide his or her consent, and that is to despite being offered continued employment on the same terms and conditions of service, there cannot be a transfer of his or her employment from one organization to another. And of course, it shall be a commercial call for the transferor entity, the seller in this case, to dispense with the employee's services as per the terms and conditions of current employment agreement. And why this is important? Because if there is no consent under the industrial relations law, which is the IDA, that employee who falls within the category of workman will be deemed to have been retrenched. And that is the point where you need to look at the scenario, if at all there is a possibility of accommodating the services of that individual within the current setup, or you need to comply with the necessary requirement for retrenching that person who has refused to consent to his transfer along with the business undertaking. Uh, Now, separately, the above conditions which I just spoke about are only required to be adhered to in case of transfer of an undertaking. And now this is another important aspect. When I say undertaking, it has been defined under the Industrial Disputes Act to include any establishment where business, trade, undertaking, manufacture, or calling is being carried on. It is also clarified that where there are several units or branches within an establishment, a unit or branch would in itself be considered as an industrial establishment or undertaking if it is severable from the other units of the establishment. So please be mindful of the fact that within an organization there could be different business verticals or divisions, or even a departmental function which is something which can thrive on its own, which is not largely dependent on other functions or other business verticals. If that is carved out as a different business vertical for the purpose of a corporate restructuring, that would also essentially form an undertaking for the purposes of Industrial Disputes Act. Now, we talk about the manner of transfer or transition of workforce. This is something which forms the bone of contention between the parties to a transaction. Employment of workmen category employees proposed to be transferred continues as is, and all their accrued and cumulated benefits get carried forward to the transferee entity. The transferent entity will be expected to pay regular salary and deposit statutory contributions in respect of such employees up to the day preceding the transfer date. So you have to be careful about the fact that entire gamut of procedural requirements, the softer nuances of determining the date of employees transfer, looking at the payroll processes, etc., all of that needs to be prepared well in advance before you intend to effectuate the transfer of these employees who are associated with the business vertical sought to be transferred as part of the corporate restructuring process. Now, the accrued benefits such as gratuity and accumulated earned leave would get carried over to the transferee entity. The value of statutory and contractual liabilities so assumed by the transferee entity can thereafter be adjusted against the lump sum consideration, which is otherwise forming the part of purchase consideration for the larger transaction. Now, this is something which is commercially discussed and agreed upon, but in majority of these instances, unless and until we are talking about a funded liability for gratuity, you look at the possibility of ensuring that you do an actuarial valuation for the total gratuity liability for employees who are sought to be transferred from the current employer to the new employer, which is the acquirer of the business vertical. And basis that, you determine the value which needs to be adjusted against the overall purchase consideration payable by the acquirer to the seller. The reason being assumption of liability on a continuing basis by the acquirer. Another important point which I already spoke about in short is no less favorable terms. Now, this is a term which is enshrined in the law. It is also something which is spoken a lot about. But the question is, what do you mean by no less favorable terms? Uh, the services which are going to be transferred on continuity basis would really be enshrined in a manner where all these employees are going to enjoy terms and conditions which are largely similar or identical to what they have already enjoyed with their current employer. Now, the phrase in any way uh, less favorable to the workmen does not mean that small infractions in the benefits or conditions of service till now enjoyed by the workmen under the former employer would render the conditions of service less favorable to the workmen under the new employer. So courts in India would usually emphasize on comparing the terms and conditions as a whole. Now, this is very important. Terms and conditions as a whole need to be taken into account as opposed to looking at pockets of what benefits are being provided or currently enjoyed by the employees with the former employer. And two, checking whether there is any material condition that is less favorable. Now, when I say material condition, you need to bear in mind that under any corporate transaction which involves specifically the business transfer on a lock stock barrel basis, uh, the remuneration structure of employees, especially I'm talking about the workmen or protected category, that needs to remain intact. So to that extent, while you can look at probably changing the constituents of the salary, but the quantum, the overall quantum of salary which is otherwise payable to the employees must not undergo change, because that is something which strikes at the very root of this particular phrase which talks about no less favorable terms. Uh, Now, from a practical viewpoint, when it comes to dealing with HR related aspects for any corporate restructuring deal, to ensure this, it would be imperative for the transferee entity to review and assess the transferring non-managerial employees' remuneration structure and associated benefits with the transferor entity, and ensure that overall compensation, which includes the remuneration and associated benefits for these employees, remains intact to the extent possible. A practical example in our experience while advising clients in such transactions, there have been scenarios where the transferor entity provides higher benefit entitlement than what is statutorily mandated. Now that becomes a challenge for the transferee entity to replicate, considering the impact it would have at an organizational level and the costs that are associated with it. For instance, the transferor entity may have a policy of making gratuity payments on an uncapped basis, whereas the transferee entity may have a policy of capping the gratuity payments to the statutory limit of 20 lakhs rupees per month. Now, in these situations, and from a risk mitigation standpoint, it would be important for both the transferor organization and the transferee organization to have an appropriate paper trail and relevant documentation and seek express consent of the transferring employees to change any proposed to the existing terms and conditions of their services, specifically to the existing salary structure, contractual benefits which they were entitled to during their employment with the transferor entity. Another aspect which is equally important, uh, because I just talked about transfer on the basis of continuity of service, the question arises, what if, as part of the commercial arrangement which is envisaged by parties to the transaction, does not envisage a clean slated approach of transfer of employees? And in that case, a situation would arise where the acquirer is of the view that assumption of liability for employees right from the day when they joined the services of the current employer is not something which an acquirer is keen to assume as the new employer. In those cases, we would normally look at the possibility of transition of the workforce associated with the business vertical on the basis of resign and hire. We usually call it the hybrid model. Now, as an alternative to the approach of transferring an employee's services on continued basis, workman category of employees may also be provided with an opportunity to voluntarily resign from their employment with the transferor entity on and with effect from day prior to the transfer date. As such, the transferor entity would be required to simultaneously ensure payment of all statutory and contractual dues, for example, gratuity, leave encashment, notice salary, which is otherwise payable as per the employment contract terms. Now, these employees would then be required to be hired and onboarded by the transferee entity on fresh terms immediately after their release by the transferor entity. Now, under this option, the transferee entity would be free to offer employment terms as they may like. It is advisable, it's a very practical proposition. It is advisable that this employment offer would set out terms that are largely comparable in aggregate, especially in terms of existing remuneration, to the existing terms that are currently enjoyed by the employees who are proposed to be transferred. So while you may have a practical call or commercial arrangement to offer employment on new terms, on fresh terms, but do see from a strategic viewpoint as to whether the workforce which is transitioned under this model would be amenable to that kind of an offer being made, because nobody would want to lose out on the benefits that are core to them. So this is something which is equally important from a practical perspective, not just from a legal standpoint, which I just spoke about in the previous slide. Now, when I say hybrid model, I would like to emphasize on the point that parties may also agree on a resign and hire model for the transition of employees' engagement, where they resign from the services of the transferee entity, employed with the transferee entity with no service continuity except for the understanding that the employee's employment tenure with the erstwhile employer, the former employer, shall be recognized only for the limited purpose of computing gratuity liability. Now, usually we talk about gratuity eligibility criteria being minimum 5 years of continuous service as per the Payment of Gratuity Act. Now, in this instance, the value of accrued gratuity liability so assumed vis-a-vis the transferring employees by the transferee entity will be adjusted against the purchase price consideration, which is otherwise payable by the transferor entity. This is more of an accounting perspective, and based on the commercial understanding between the parties, but assumption of liability in this case where employees are otherwise joining under fresh terms based on the offer of employment made to them by the new employer, the acquirer, you need to determine the value of gratuity liability, which is assumed on a limited basis as part of the corporate arrangement between the two entities. Now, the aspect of deciding the manner for transition of employees' services would largely depend on the nature of corporate restructuring and the commercial understanding between the parties. Moving on to the next slide. Now, another question that arises from time to time is we talk about workmen, we talk about protected employees, but what happens to the employees who are falling in the non-workmen category? Now, as discussed in the previous slides, categorization of employees as workmen and non-workmen as per the Industrial Disputes Act is a subjective assessment. It may also be a time-consuming process because the categorization of employees into workmen and non-workmen cannot be solely done based on employees' designation and quantum of salary which is payable to them in ordinary course. Now, to avoid ambiguity and administrative inconvenience to the transferor entity for categorizing an employee as a workman or non-managerial employee under the IDA, it is a common practice for the transferee entity to adopt largely a universal approach for all employees, including managerial personnel, and adhere to the terms and conditions prescribed under the Industrial Disputes Act, which I just spoke about in the previous slides. Now, that is largely to ensure that the transferring employees are not prejudiced as a result of the transition and may accordingly accede to the arrangement more quickly and seamlessly. So the idea is not to carve out a distinction as part of this corporate transaction between two categories of employees, unless the corporate arrangement between the two entities or parties to the transaction is such that assumption of liabilities is only limited to employees who fall within the workman category. But largely, basis our experience, we have seen that the seamless transition would entail categorization of employees on an equal footing, and the entire perspective of how to transition the workforce is not based on the assessment of their duties and responsibilities as workmen or non-workmen. Now, looking at this slide on the perspective of share acquisition and transfer mechanisms, in the event of corporate restructuring that entails a change in the shareholding pattern of a company, the employer entity of the employees engaged shall largely remain the same. Now, to clarify, the employer-employee relationship between the employer entity and the employees engaged shall not be impacted, resulting in no change in the employer, and therefore the terms and conditions of services will not be impacted under any circumstances. Accordingly, in these scenarios where there is a change in the shareholding pattern of a company, the acquirer needs to ensure that it has undertaken a thorough diligence on the employer entity, the company, the target, which includes the engagement policies, the employee policies, and practices which are adopted by the employing entity. The company's compliance status with the applicable labor laws is equally important to be looked into. Now, any non-compliance by the employer entity under applicable labor laws would need to be rectified to the extent possible, largely as a pre-closing proposition. In many instances, you may look at post-closing action items also as part of the understanding between the parties. But this is something which is equally important in a share deal, because in those instances, you are stepping into the shoes of the current employer as a majority shareholder. Now, do note that conducting extensive due diligence on the target entity from an employment law standpoint becomes imperative to assess the non-compliance, the risks and liabilities associated with these non-compliance, and agreeing on the manner to mitigate such risks or non-compliances from future standpoint. A very quick practical example. In one such matter, a client had reached out to us to assess the mitigation strategy for non-compliance of the target entity under the Employees Provident Fund Act. Now, there was a shortfall which was committed, which was essentially emanating because of certain issues that arose prior to consummation of the transaction. Now, the defense of the acquirer entity was that they were not in control of the organization at the time of commission of such non-compliance under the statute. Now, these submissions arguments shall not assume any relevance, as it shall be the responsibility of the entity which has failed to comply with the provisions of EPF Act, and the responsibility of rectification of this non-compliance or payment of liability towards shortfall of the contribution under Employees Provident Fund Act shall be of the entity. I mean, of course, without the authorities delving into the aspect of if there has been a change in the shareholding of the company post commission of such non-compliance under the EPF Act. Now, in this regard, it becomes important to assess the compliance status of the target entity and seek specific clarifications, specific indemnity in certain cases, in case of any assessed major non-compliance under the applicable law as a potential risk mitigation measure for the future. Moving on to the next slide. Now, another scenario which comes into play, we already spoke about business transfers, share acquisition deal. Uh, Another way of corporate restructuring being effectuated is through mergers, demergers that would entail approval or sanction of the competent courts for such restructuring. Now that renders the process to be court driven. Accordingly, the court sanctioning the merger or demerger scheme shall set out the manner or procedure concerning the transfer or transition of the workforce with the newly demerged or merged entity. Now, as is commonly observed, the scheme as approved by the competent court would generally prescribe conditions for transfer of services of employees or workforce associated with that particular entity, akin to the stipulations that are already set out under the Industrial Disputes Act. So the principles which I just spoke about and emphasized on would form the basis of the conditions that are set out by competent courts for transfer of employees or transition of workforce under an approved scheme of merger or demerger. If you look at the corporate restructuring aspect, which involves trade unions, and this is very important from an industrial relations standpoint, the parties to the transaction may need to undertake an assessment of the unionization details. That is the first bit about status of on-ground industrial relations with employees and any existing trade unions on the premises. It may be for a manufacturing establishment, it may be for a services sector company, but all the more it is important for any acquirer to assess the nature of industrial relations on ground. Now, existence of any collective bargaining agreement for determining contractual stipulations which may be relevant for a corporate restructuring is equally important. There is no statutory requirement to obtain trade unions' consent in the event of corporate restructuring. Having said that, it would be prudent to consult and liaise with the union members, the office bearers, to discuss and apprise them of the corporate restructuring exercise which is on the anvil. Now, the timing of that is important. In many instances, questions have come before us as to whether it would be important for the parties to the transaction to disclose the proposed transaction to the office bearers of a trade union in advance or way in advance of the transaction, or is this something which may not be aligned with the overall disclosure requirement for the authorities? So from a statutory viewpoint, you need to bear in mind any specific regulatory implications which may come in, where you need to disclose the potential transaction to the office bearers in advance of the transaction. Largely, it is more of a softer nuance where you look at the collective bargaining agreements, you look at the stipulations that may be there from the perspective of seeking any specific consent or consultation with the office bearers of a trade union when it comes to the nuances involved in transferring or transitioning the workmen engaged with the business which is sought to be transferred or transitioned as part of a corporate restructuring process. Now, while navigating with trade unions can certainly add more work to a corporate restructuring of share acquisition or equity purchase, the largely better news or better perspective for acquirer entities is that trade unions cannot unilaterally block transactions. Now, we have seen instances where, in certain instances, trade unions have come up challenging the overall deal which is currently proposed by two or more parties to a transaction. But this is not something which can be legally tangible before the courts of law, because unless and until there is a scenario where unfair labor practice is highlighted by a trade union, especially in the state of Maharashtra, we do not see the possibility from a legal standpoint for trade unions to unilaterally block a corporate restructuring deal. The presence of a trade union will not always be problematic in a deal scenario, but those involved in a share acquisition deal in which a target has an active trade union should, of course, be mindful of the requirement to have sensitivities of trade union members to be kept in mind, and of course acknowledge the terms and conditions agreed with such trade union members by way of a wage settlement agreement or any specific charter or demands which have already been agreed and taken on record. Modifying the benefits already promised to the trade union members may have an adverse impact on the functioning of the organization, and the acquirer entity shall need to tread carefully in case it has to do so for business reasons. Now, some of the key takeaways as you look at the slide in front of you. Now, given the above employment law considerations in the corporate restructuring processes for corporate entities, it would be prudent for parties involved in any such deal to assess the nature of the deal, the transaction which they are currently envisaging, whether it is a business transfer, whether it is a share acquisition or a court-driven merger or demerger at the outset, and the nuances that concern employment law aspects under the current mandates. Uh, what is really of significance will be that in business transfer or asset purchase transactions, while the Industrial Disputes Act provides for transfer of employees' services on continued basis with no less favorable terms and conditions, the parties to such transactions may also assess and agree for transition of employees on a resign and hire model. So this is not something which is alienated from the usual practice which parties to a transaction may agree to, and this is not something which you need to be completely adverse to. This is one model which you can always consider as part of a corporate restructuring transaction. Needless to mention that the documentation or the definitive agreements which will be coming into play for such arrangements have to be very carefully drafted. The verbiage cannot bring in the element of involuntary separation of employees as part of corporate restructuring process where employees are otherwise meant to move voluntarily after relinquishing their roles with the current employer. So this is equally important as a takeaway in terms of the slides which I previously covered. So I would like to end this session in terms of what I wanted to cover on the practical and statutory side. Questions from the audience?
Thank you, Anshul, for that exceedingly detailed and thorough presentation. It's very much the reason why you continue to be my go-to advisor. I think you've covered most of the aspects. We have a couple of very interesting questions from the audience. Um, One of the questions that we've received, is relating to the value um, that one can ascribe to employees. Now, as you know, in a slump sale or a business acquisition transaction, the asset is ascribed a value, and in the purchaser's books, we often resort to what is known as purchase allocation to various aspects. Uh, a rudimentary question, but an important one. Do you ascribe value to employees from a monetary perspective? I mean, of course, employees continue to be very valuable, but purely from a monetary perspective, when employees are moving as a bulk pursuant to business transaction, do you ascribe any monetary value to employees?
Thanks, Urvi. I think it's a very good question, but emanating largely from the tax domain because no lock, stock, barrel sale will be effectuated if you, I mean, of course, from a current regime standpoint, we have largely seen that a value is ascribed to employees. I'm not just talking about gratuity liabilities or leave encashment liabilities. It is also about the expenses which one would incur or ascribe to transition the employees from the current setup to the new setup. Of course, we are talking about people as capital. And the moment we call people as capital, you do ascribes a value. But the methodology which comes into play is something which is largely emanating from accounting viewpoint. So what value exactly will come into play is something which needs to be dealt with from a tax and accounting viewpoint. But yes, if you ask me from a transaction viewpoint, yes, we have seen employees getting valued, and that value is largely determined from the perspective of how they will move alongside the business vertical which is meant to be acquired by the purchaser.
Right, right. Thank you so much. Shout out to our audience. Please keep your questions coming. We have about 8 or 9 minutes to take these questions. Anshul, the second question is, another structure that we as law firms, Indian law firms, advise considerably, and you've sort of handheld my team a lot on this, is indirect share acquisitions. When there is no direct change in the entity, and let's say at a grandfather level, there is a change in owners. Let's say another overseas buyer selling the company to another overseas buyer. Nothing changes at the Indian subsidiary level. Is there any impact on employees? Are there any consents? Anything that we should be keeping in mind?
So not an immediate requirement, Survi, but I think for all our audience, what is important is that don't just think that changes are happening at the grandfather level. Then there is nothing which is per se required because any change which may happen at overseas level may also entail few changes at the local level, which may include change at the board level. And when I say changes to the board of directors, there may be a scenario where the question about change in occupier or change in ownership, where you have a designated member of the board named as owner for the purposes of EPF Act or ESI Act. Some of those aspects are very instrumental and fundamental to transactions of this nature. And apart from that, another important point will be where you may want to align the current setup which employees are a part of with your global policy perspective. So if
Right.
there is realignment of policy framework, that is something which you need to see in advance as to where things lie. And I'm talking about both monetary as well as non-monetary benefits and policy consideration. So from the perspective of an indirect change, where nothing is happening really effectively at the local level, but employees may be proposed to be falling within the ambit of larger policy framework, that alignment is something which needs to be looked at from a softer nuance standpoint. And if there is anything which needs to be redrafted, that is something which may be, I would say, more carefully dealt with, because terms and conditions under those scenarios should not lead to any specific advance notice requirements for employees who fall in the protected category. I just spoke about workmen. So that's something you
Right.
need to be mindful of.
Absolutely. Um, this reminds me, my next question actually reminds me of a very interesting anecdote. A friend was looking for a change in a job, and the prospective employer, and she was negotiating her designation with the new employer. And the new employer said, don't worry about the designation, you should worry about the role we are giving you. Is that true for business transfer acquisitions when you talk of parity? If there is the role remains the same, but if there's a change in designation from a potato to a potato, do you think that impacts, how you would look at things? Does it mean that you're employed at the same terms if you're no longer given the same designation?
Very interesting point. And of course, when it comes to transactions which involve India or are India focused, uh, I would say a substantive majority of workforce are very sensitive towards the titles they carry as employees. Now, a quick example of somebody who is currently carrying the designation of a vice president,
Yeah.
but when it comes to transition of their services, the new designation will call them manager. From a legal perspective, no issues at all if you are ensuring as a new employer that the remuneration structure, the quantum of benefits, all of it is largely intact. There may be some differences here and there, but yes, you need to ensure that there are no surprises. And that is where on one of the slides, if you see, we have already captured that point, that if there is any different factor which comes into play for their continued employment with the new acquired entity, the new employer, that needs to be coming upfront. The moment you have employees onboarded and then they are coming in for a surprise that their designation is undergoing change, it is not about the law, it is also about dealing with the sensitivities of employees. And this is a very minor issue, but may tend to disrupt your business, your operational viewpoint from day one.
Understood. Understood. Anshul, another question that we've got from our audience is it may be an academic question because my sense is that we deal with it practically, but I want to understand what you think about it. Is what if the employee, the transferring employee, has consented in a business transfer situation for a transfer, but the transferee has not accepted it? Does it, what is the impact then? I mean, I think you and I know the answer, but just for the benefit of our audience, in a situation where the employee has consented for the movement from the transferor to the transferee, but the transferee hasn't accepted his employment, what are the implications?
So I think this aspect was covered very briefly in one of the slides, but uh, we it's the other way around. If the consent is not there and the acquirer is ready to take on or onboard the employee, the transfer cannot be effectuated, and in that case, the provision of deemed retrenchment for protected employees who are workmen will be triggered. But in this instance, which you just spoke about, Surbi, we have seen it all. There have been multiple instances where there could be a cherry picking of employees. People have already
Yes.
accepted an offer, are not being onboarded. Now, in those scenarios, specifically, we are talking about the non-managerial personnel, people who are likely to fall within the category of workmen. The deemed retrenchment provisions will come into play, and that is where it is very important to have the necessary verbiage in the definitive agreements to determine who
Correct.
is going to be liable to meet those obligations to pay compensation to employees who may have consented to their transfer but not eventually being onboarded, because ultimately they are at a loss. And that's something which I spoke about in the beginning of the session, that employees perspective should not be adversely impacted. So the moment we are talking about a scenario where the employee is going to lose out on potential employment because of the deal, which is on the anvil, in that case, either you are accommodating the employee in a similar setup as the current employer, or you look at the deemed retrenchment provision. For managerial personnel, completely driven by the terms and conditions of employment at present, notice salary and other benefits are required to be payable if you're not able to accommodate the managerial personnel who are otherwise consenting to their transfer as part of the deal.
Absolutely, and to just sort of add to that, in most M&A transactions, it's a condition precedent for the transferee to accept the employment. Because as you very correctly said, if there are retrenchment provisions, that is an additional liability on the transferor's account, and the transferor would not want any of those. So there's clearly, from a documentation perspective, we as when we are drafting that contract along with your team, we ensure that there is an adequate condition precedent as well that is built into the document to ensure none of these situations arise.
Right.
So thank you for that. Anshu, the next question is, in again, most of our questions are with regard to business transfers because that's really the more complex aspect. Is how does one deal with variations in employee policies, such as leave entitlements, gratuities, and various other things between a transferor entity and a transferee entity? And I know in one of the earlier slides you mentioned that we have to look at it in totality. But if there is a difference, how deep do you go, and how do you then sort of as an advisor, how do you assess whether the policies are no less favorable when you talk of leave entitlements, gratuities, and things like that?
I think fundamental question. This is something which we deal with at the outset for any business transfer transaction, because the first suggestion, first advice from our end is to ensure you look at all the policy considerations, especially the monetary benefits, very carefully, because if there is any difference on the fundamental viewpoint of how you are computing some of those benefits, and especially I'm talking about gratuity and leave entitlements, and I'm giving a very quick example. In some of the instances, leave entitlements are based on the basic salary. In certain instances, it is based on the full salary of the employee. Now, there
Okay.
could be a difference of opinion between two entities. The transferor entity observes full salary computation. The transferee entity says, I will only compute on basic. I won't get into the legal implications of that, but this is something which you need to assess well in advance. And if there is any difference of how you quantify these leave accumulation benefits, as well as gratuity entitlements, which could be going beyond what is statutorily limited under the law, then that needs to come up much in advance as part of the tripartite documentation, which is usually entered between the employees, the transferor, and transferee. But yes, it needs to be determined, because it's not just about communicating to the employee, it is also about determining the value of liability which you are going to assume. And from the perspective of the transferee entity, it becomes imperative that you already have it on record and you have conveyed to the employees, and also for your auditors to determine that not the liability basis what has been followed as a practice in the past, but the liability which is based on my practice as the new employer. So yes, I mean, there is no straightforward answer to it, but largely dependent on how you are prepared in advance of a particular transaction when you are dealing with monetized benefits for employees who are proposed to be transferred.
Absolutely. We're actually completely out of time and we have a bunch of questions to deal with. So maybe, Anshul, just one last question before we wind up. Um, in your experience, and this is more from a practical aspect, I think you've been very comprehensive in, elucidating the various legal and technical aspects. Now, maybe from a practical aspects, um, have you ever seen of a tough trade union when in their collective bargaining agreement they are not playing ball with the transferee entity, and practically how do you deal with this? I mean, legally we know there is an agreement and there's a collective bargaining agreement and things like that, but from a practical perspective, because I know that you do a lot of that kind of work also, practically hand holding a lot of our clients in these issues, but have you ever seen a scenario where a trade union or let's say a category of employees are sort of acting difficult, and that can have the potential of delaying the deal or delaying deal closure?
No, I think this is very important for any party to the transaction to assess how the trade unions can play an important role in either streamlining or disrupting your operations from the perspective of effectuating this deal. And yes, we have seen instances where trade unions can act very difficult, and communication, there is nothing always legal about it, but communication becomes the key factor here. In several instances, parties have probably undermined the strength of trade unions of, let's say, on the premises or even locally, where they have joined hands with the umbrella trade union organizations or federations to come up with specific concerns on how the employees are eventually going to move. And there could be situations where you don't hold dialogues or discussions with the office bearers, and they will allege that they have been kept in dark on what exactly is on the anvil for the workers. Either they are affiliated to the trade union, or even for non-unionized workforce, what exactly is on the anvil. So the idea is not to just look at it from a myopic viewpoint of how we are dealing with these factors from HR perspective, but also taking the unions into confidence is equally important. And
Right.
yes, last point is about charter of demands, which may be ongoing or which have already been negotiated. The moment you step into the shoes of the establishments which currently employs these unionized workers, you need to take those agreed charter on demands on record to say that there is no change in the core terms and conditions of service for these workers who are proposed to be transitioned from one entity to another.
All right. Thank you, Anshul, so much for this. I'm completely out of time. We won't be able to take all of the questions, but be rest assured we will, respond to each of them separately. To just sort of summarize, Anshul, the way I sort of see this entire human capital issue and M&A transaction, the three or four main takeaways for me as an M&A lawyer. First and foremost is homework is the key. We must not leave employment issues as an issue to be dealt with later in the day. When you're making your list of four or five critical issues for an M&A deal, one must assess how critical the employment issue is, and we must do our homework. I think the key is in early identification, and that goes a long way in smooth transitioning. The second is ascertaining liabilities and factoring those in the cost sheet, whether through an actuarial valuation, financial due diligence, legal due diligence, understanding where the pitfalls are, what the non-compliances are, what is the cost for transitioning those employees, maintaining parity in terms of employment. And the third and most important thing that I think you mentioned in your concluding remarks as well is constant interaction, back channeling, communication. I think at the end of the day, uh, any inorganic growth is a key point for both transferor and transferee companies. It leads to uh, very justifiable insecurity issues. It's important for the key players on both sides to constantly interact with the employees and to tell them that their concerns will be taken care of one way or the other. So don't leave employment issues as a segue. Please deal with it as an important and integral part of M&A transaction. I've been doing that, and I only find that the more I interact with my employment colleagues from Anshul's team, the smoother things are for me when I proceed. Uh, Thank you so much, Anshul, for taking the time out. Before we close, may I request our audience to please take some time out and respond to the poll slide. Prajay, if you can just project the poll slide. Um, we take your feedback very, very seriously. It helps us curate our programs for the future. The improvement that you've seen over the years and months in our M&A Academy programs are all thanks to your feedback. So please do give us honest and constructive feedback. Um, Thank you, everyone, for taking the time out and joining us for this webinar. Thank you for your feedback, for your questions. Anshul, thank you to you and your team who worked to get this presentation in a very succinct and precise manner to us. We enjoy bringing these webinars to you. Keep your suggestions coming. Let us know what more we can do to make these sessions meaningful. After the webinar, we will of course send our audience a copy of today's presentation materials and summary notes. You will separately receive again a request for feedback, so please keep that feedback coming. And keep watching this space. We are available if you have any further questions for us. Our contact details are on the slides here. um, keep your suggestions coming, keep interacting with us. We enjoy bringing these sessions to you, and I hope you found it worth your time. And keep watching this space for more very interesting M&A topics in the future. Thank you, good afternoon, and bye bye.
Thank you very much.